Okay, now we are going to leave the judicial/court system and we're going to go to more administrative agency type decisions and some statutes that have come up that are new and that may affect you again as you're in your board membership. So first, School Ethics Commission, which are cases which are always near and dear to your heart. We have Hadrinsky versus Fawcett. This was a case August 30th out of 2021. In this case, a board member asserted that another board member had posted several incendiary and racist memes and videos on his personal Facebook page. This is always an issue, social media and what board members can and cannot do, what they should and should not do. In this case, the School Ethics Commission found no violation and that there was no nexus between the respondent's Facebook page, role membership on the board, and no personal promise of any specific related action to board business. And the School Ethics Commission granted the motion to dismiss. Now, these cases are always something that they're interesting. We're never quite sure where they're going to end up on these cases. We bring this up as a case that was recent, but also urge you to watch upcoming. There will be presentations coming forward involving specifically the role of social media and the board member. Hopefully that you will be able to look on our website and find that presentation. And as always, you can always call us and ask any questions, but also seek the official advice of your board attorneys, especially in School Ethics Commission matters. Additionally, just since we are on School Ethics Commission matters, it's not going to be part of this presentation, but at the end of 2021, the School Ethics Commission did add about 10 different advisory opinions, and we always use those advisory opinions to help us give you information, and hopefully they are of good use to you as school board members. But since those 10 cases alone could take up this entire presentation, we're going to have that as a separate presentation that will be available to you throughout the year, but we weren't going to add all of those cases to this presentation right now, as it would essentially take over the entire presentation. But please just know that those are out there. If you want to go to the School Ethics Commission website, on the Department of Education's website, you can see those advisory opinions listed, and they are for the entirety of 2021. Okay, cases that went to the Commissioner of Education. We have Montcor versus East Orange Board of Education, and at this time, this was a case in which the acting commissioner found that the non-renewal, you have to follow along with me, non-renewal of a non-tenured math supervisor was not improper, even though the Board of Education failed to properly or timely complete the evaluations of that person. Again, this is the non-renewal of a non-tenured math supervisor. In that case, the commissioner found that a Board of Education has virtually unlimited discretion in the hiring or the renewing of non-tenured staff members, absent constitutional constraints or legislatively conferred rights. The petitioner in that case argued facts not supported by given reasons, but the violation of constitutional or legislatively conferred rights were not alleged. So in that case, essentially saying that the petitioner did not write the greatest of complaints, and additionally that the Board of because this person was non-tenured, and that they essentially have unlimited discretion in the hiring, and because they failed to properly or timely complete the evaluations did not mean that they had to automatically re-employ this person. Nazir versus Patel, a case out of the Commissioner's Office, August 21st, 2021. In this case, a board member was distributing flyers that were urging voters to vote for a specific political party, indicating that the complainant in this case, a person campaigning also for board membership, was the leader of a, quote, radical group who was going to take over the town government. In this case, then that person challenged and went to the School Ethics Commission against this seated board member and said that challenged that this was a violation of the School Ethics Act. And the board member used their title on these flyers as a board member, put on there that they were a school board member and used no disclaimer. And as school board members, you are all aware that how important it is that if you are speaking on your own behalf, that you make it clear that you are doing so and that you are not speaking on behalf of the board, and so that there was no question as to that. But in this case, that board member did not do this, and ultimately the commissioner concurred with the School Ethics Commission's recommendation for the penalty of a censure. So the school board member was censured for distributing these flyers and making those both indicating that people should vote for a certain political party, as well as disparaging another person that was running for board membership. Just as a little primer, just as a reminder, School Ethics Commission has the final say on whether or not there is a violation of the School Ethics Act or the Code of Ethics. But if they do order a penalty, that penalty has another level of review with the commissioner, which is exactly why this case went to the Commissioner of Education only as to the penalty. So the commissioner could not come in and say they disagreed with the School Ethics Commission's determination of a violation, but they could change or modify the penalty. In this case, they agreed with the School Ethics Commission and said that the penalty of censure was appropriate. But just a reminder that the School Ethics Commission does not have the final say on penalty, although it is often, they are often given the deference with regard to the penalty. Every once in a while, the commissioner does have something to say about that penalty. Still before the commissioner, we have RH versus Sayreville Board of Education. In this case, the commissioner concurred with an administrative law judge who heard a hearing that was in favor of the board, where the parents brought a challenge to 2 board HIB determinations. So in this case, HIB determinations were made by the board. They then went to the next level, where the commissioner had this matter go before the administrative law judge for a full hearing. And in this case, first, the student committed acts of HIB by creating social media posts outside of school depicting friends in blackface. And 2, the student was not a victim of HIB following incidents where students were allegedly was called a racist by other students and commented inappropriate but no substantial disruption to school or rights. So the commissioner did agree with the board in these cases, one in which the board did not find HIB, and a second where they did. Again, as these HIB cases are always very, very, very fact specific. And again, just because we often get questions about how could you not find that this is HIB, just remember, and you will get, as you always do, you have your consistent HIB training, and the law is always changing. But remember, HIB is a very specific finding, and there are very specific elements that have to be in there to make that finding. And if all of those elements are not there, then you're not going to get HIB. But it does not mean that it may not be very simply a student disciplinary issue or some other violation of a school policy or procedure. So just because something is not HIB, remember, it could still be definitely fall under some sort of disciplinary violation within the district. It is just not an HIB violation. It's just something that often throws a case out of violation finding is that substantial disruption to school or rights. So if something that only does not happen publicly and does not cause a student testifies that there was no substantial disruption to his or her schooling or her schoolwork or grades, then there's the possibility that they're not going to find that it was an actual HIB violation. Again, doesn't mean something else doesn't exist as some kind of violation. Jones versus Winslow Township Board of Education. In this case, there were tenured teachers. Both had corrective action plans going on and going into the 2019-20 school year. They appealed the determination to withhold salary increments in 2021 because they had partially effective summative ratings, and again, were both under corrective action plans. And so this was a matter of whether or not that withholding of salary increments was appropriate. The commissioner affirmed the administrative law judge finding that the board improperly disregarded Executive Order 103 by not giving non-evaluated ratings that year, and therefore acted arbitrarily in using evaluations as a basis for increment withholding. So this is very specific to COVID. Just a reminder that this may not going forward be something that you would want to rely on. But because of Executive Order 103, which withheld, which saying that there were supposed to be non-evaluated ratings given out during that time, that the evaluations that were done should not have been used to withhold salary increments. But again, this is very, very specific. This is one of those things we warn you not to use going forward, because this case is so case specific. It's truly going to be based on the COVID times and exactly what was done. But in this case, it was found that they should not have used that summative rating in order to withhold a salary increment, only because of Executive Order 103, which was where it started all of the COVID-19 executive orders that came thereafter. Okay, this is a very important case that school board members are going to want to pay attention to. In the matter of Tristan, this is a case in which a school board member wrote an op-ed piece endorsing some school member candidates while disparaging others. Now, in this case, the board member did include a disclaimer with the language, but created the impression that it was the board's opinion and not his alone. So he said all the right words, but he did not. He still went ahead and said things that were violative of the School Ethics Act, and alone the disclaimer would not give one the impression that he was only speaking on his own as opposed to speaking for the board. So this is a kind of a warning that, again, just because you put the disclaimer, if there are other words or actions or optics in whatever action you are taking that still makes it sound that you are talking for the board, you need to be careful. Simply just putting the boilerplate disclaimer language in whatever it is that whatever communications you are using is not enough if it makes it look, if that alone, if the rest of the language still makes it sound as if you were talking for the full board. So in this case, the School Ethics Commission found a violation and said that alone the disclaimer is not enough to just cure everything that you might say thereafter. The acting commissioner agreed, still found that there was a violation. However, they did do something which is a little sometimes not done very regularly, but they changed the School Ethics Commission recommended penalty of censure down to a reprimand. Like I said, very often the commissioner does give deference to the School Ethics Commission because that is their subject matter specialty. However, the commissioner is the final decision maker with regard to penalty. So in this case, they felt that a reprimand would have been the sufficient penalty in this case, and it did not rise to the level of censure. Again, this doesn't happen a lot, but it does happen, and this is what the commissioner felt was appropriate. But this is something that should really, if you have to keep a case in your toolbox just for things, for First Amendment issues, what you can say and not say as a school board member, you just want to remember that just because you put in the boilerplate disclaimer language, that you can go ahead and say anything that you want. It still has to be consistent with the spirit of the disclaimer that says that you are not speaking on behalf of the board. Moving on to a case under the Government Records Council, which is the agency that oversees the Open Public Records Act. We have a case coming out of that agency, SV versus the Morris School District. And this is a case where the complainant submitted an OPRA request for, among other things, special education, education files, health records, and communications about a specific student. The GRC, the reason why we point this out is that they reiterated their interpretation of a former case, which is a pretty big case out of Camden City, and in that case, it found that to allow for the disclosure of student records under OPRA, where the requester could substantiate that they were an accepted party, the existence of other statutes regarding the management and disclosability of student records does not infringe on an individual's right to submit a request under OPRA. So in this case, it was decided that an OPRA request, they're not going to chill that the requester was allowed to make this request, and that they were somebody that was not considered an accepted party, and that they did have the ability to make the request, and then it would be on the school district to decide what it is they can and cannot turn over.